international human rights law sets forth that all are equal before the law and are entitled without any discrimination to equal protection of the law. Additionally, governments have incorporated equal protection and non-discrimination clauses into their constitutions, and many have adopted anti-discrimination laws. Yet, in practice, criminal justice systems in countries around the world discriminate against and disproportionately criminalize people who are marginalized because of their economic and social situation, as well as other characteristics such as race, caste, ethnicity, religion or belief, disability, nationality, gender, and sexual orientation. In this panel today, we have an incredibly distinguished group of speakers who are going to shine a light on the complex and deeply rooted causes of disparities in criminal justice systems and the ways that they permeate every stage of the criminal justice system, from arrest to trial to sentencing to post-release experiences. These panelists will also call attention to the need to establish an international group of experts from government, civil society, academia, and including persons with lived experiences that can provide advice and assistance on concrete measures that will reduce both the existence and impact of discrimination and inequality. Further, although there has been progress made and increasing attention to inequality and discrimination in criminal justice systems, the data is showing us that disparities in treatment in criminal justice systems is actually getting worse, demonstrating the need for critical attention. Our panel will also call attention to the need to establish an international group of experts from government, civil society, academia, and people with lived experiences to assist in charting the way forward as to how do we address this problem. This event is organized by the International Legal Foundation with the support of the governments of South Africa, the United States, and with the United Nations Office of the High Commissioner for Human Rights, the Brazilian Federal Defender's Office, Defensoria Pública de UNAIA, the Campaign to Decriminalize Poverty and Status, African Policing, Civil Oversight Forum, Amnesty International, Penal Reform International, Open Society Foundations, the Kenyan section of the International Commission of Jurists, and the International Drug Policy Consortium. I'd like to welcome our first speaker, Judge Motsamai Makume, who's my colleague in South Africa, and who's also the chairperson of Legal Aid South Africa. Judge Makume, the floor is yours.
Thank you, Chairperson and distinguished guests. And thank you for allowing me to be the first speaker. The Honorable Deputy Minister of Justice and Correctional Services, Mr. John Jeffries, addressing a conference on the campaign to decriminalize poverty and status, called for the reform of the law so that poor and marginalized people not be arrested as a result of criminalizing homosexuality or sex work. It was at that conference held at Stellenbosch in September 2022 that 113 experts from 28 countries adopted by consensus the Cape Declaration on Decriminalizing Poverty and Status. That declaration called for an intergovernmental meeting of experts to study ways and means of addressing this global crisis of decriminalizing poverty and status. The South African Law Reform Commission conducted research, which it published in 2009, dealing with sex work. It was only on the 30th of November 2022 that Cabinet approved the publishing of that bill regarding the decriminalizing of sex work for public comment. It is common cause that in the past 10 to 20 years, we in South Africa have experienced an unprecedented inflow of economic refugees from neighboring countries like Zimbabwe, Mozambique, and Zambia. There is also a trend of trafficking of women from other parts of the world who are promised jobs in South Africa, only to find themselves being used as sex slaves and in brothels and massage parlors in South Africa. Section 12(2)(b) of our Constitution guarantees everyone the right to bodily and psychological integrity, which includes the right to security and control over their bodies. It is Section 22 of the Constitution, which in my view has moved government to move towards finding a solution to legalize sex work. That section reads as follows, I quote, "Everyone has the right to choose their trade, occupation or profession freely. The practice of a trade, occupation or profession may be regulated by law. Sex work is not only a trade, it is also an occupation or a profession, and persons who have chosen that trade or profession have a right to claim constitutional protection and not be persecuted. Accordingly, criminalizing that trade denies sex workers of their rights to human dignity, freedom and security of person, freedom of trade, the right not to be discriminated against, and lastly, the right to equality. Statistics have proved that it is the poor, the unemployed, and at times homeless young women who resort to sex work in order to make a living. Some of them are single mothers with children to feed and to take to school. It is therefore clear that subjecting them to arrest and prosecution also affects the livelihoods of their own children. Chairperson, conviction for any crime carries with it a stigma that in future may prevent such a person being employed, as criminal records remain on one's profile in the official books for a long time. Sex work, once regulated, will bring about binding contractual relationships, whilst at the moment there is no such protection. Instead, the authorities frown upon such action and there is no recourse for sex workers. The National Strategic Plan on Gender-Based Violence contains a list of key activities, one of which is a finalization of legislative process to decriminalize sex work. It is the belief of government and groups as well as NGOs representing sex workers that the promulgation regulation of sex work will result in the following: freedom of right to choose choice of work, freedom to form trade unions and belong to for their protection and advancement of rights, freedom from discrimination, the right to health care, freedom from arbitrary arrest and detention, and freedom from violence and abuse. In conclusion, Chair, we at Legal Aid South Africa have in the past and still advocate for establishment of an expert group to deliberate on the nitty-gritties of regulations to control sex work. We believe that such groups should include persons from jurisdictions that have legalized sex work, as well as NGOs and sex worker groups. Thank you.
Thank you very much, Judge Masume. Your
Merci, Juge Masume.
ways in which criminal justice systems often prosecute victims, in particular those who are most vulnerable than those addressing underlying abuse and needs. And I'm happy that you've also reminded us that as we are here today, there's a resolution that's being debated that aims to ensure that such a group of experts is convened to chart the way forward. Thank you very much. It is now my pleasure to introduce to you Ms. Dominique Day. She joins us online. She is a distinguished member of the Working Group of Experts on People of African Descent. And as a member of this independent working group, she has studied the scope and complexity of racial discrimination across multiple countries. She'll share some of her reflections with us today on the key drivers of racial injustice in criminal justice systems. Ms. Day, the floor is yours. Thank you very much.
Thank you, Your Excellency. And thank you all for including me in this conversation. It is quite a privilege to be able to join you here remotely. I guess I would add that one persistent challenge in human rights spaces is reconciling our commitments to human rights as overriding values with our complacency and allowing good intentions often to replace real results. And very often we fail to drill down into what guarantees exist that the protection and the promotion of human rights is afforded without discrimination and across all communities. In many areas, this is an issue that should be addressed by providing legal aid, and sometimes it is, but meaningful access to justice also requires us to confront how embedded systemic racism is in the administration of justice. In many countries and in every region, the administration of justice has allowed de facto systemic racism to persist as an everyday operating principle. In many countries, including the global superpowers of the West, systemic racism was birthed as a legal written mechanism to ensure racial hierarchy. And globally, these legacies persist today. So the working group welcomes the development of resolution that will solidify and give shape to the international commitment to equity and equality and access to justice, including through the guarantee of legal aid. And this is an area where the international community can shine in its rigorous attention to how local expertise and experiences can give meaningful content to rights. A wealth of best practices exist, and these are hard-won lessons from everywhere in the world. We've seen that access to justice is a space where getting the best minds in a room, and I've heard a lot of talk already about a group of experts, can really make a difference. And this is particularly true with respect to our obligations to dismantle systemic racism that has been embedded in our administrative justice system, that we can, so embedded that we can measure it everywhere we have the data, including in legal aid itself. So to this end, eradicating racism and access to justice needs to confront the ghosts in the machine. How anti-Blackness is a powerful colonial legacy and how bias continues to influence outcomes. There are many local manifestations, and the expertise to start to see, decode, and dismantle systemic racism exists in our midst already, if we know where to look, and starting with those with lived experience to contribute their expertise to this problem. So in the end, the resolution and our commitments must make it clear that this is not a matter of good intentions, but of good fences, as I like to say. There's a poet from my country who talks about good fences make good neighbors, a phrase that I interpret to refer to the mutual respect and recognition that underlies real consensus building. In this regard, I think we need to ask, what does it mean to embed clear parameters to keep our actions, priorities, and outcomes consistent with our stated values, including anti-racism, racial equity, and equality? Thank you very much.
Thank you very much, Ms. Day, for those concise remarks. You've reminded us of the endemic nature of racism and how deep-rooted it is, and for ensuring that we all are aware that we all have a duty to make sure that we contribute to dismantling this form of discrimination and racism in our criminal justice systems. Thank you very much. Our next speaker is Ms. Livia Caceres, the coordinator of racial justice of the National Drug Policy Office of the Ministry of Justice in Brazil, who will be talking to us about the incredible work she and her office are doing to try and address substance abuse and as a public health rather than criminal justice, a criminal justice issue. So, Ms. Caceres, the floor is yours.
Thank you very much. First of all, I would like to thank, First of all, I would like to thank Honorable Judge Mlembo and the ILF for the opportunity to participate in this event and share the Brazilian experience in the context of drug policy and the criminal justice system. Drug policy in Brazil is closely related to mechanisms of reproduction of racism. The war on drugs model mobilizes racial stereotypes, and the official policy established the figure of the drug trafficker as the enemy of society. Public security strategies divide the country into two groups of people: those who deserve state protection and those who may suffer the collateral damage of repression. Historically, Brazil chose not to adopt legislation institutionalizing racial segregation and not to expressly address the racial issue in its constitutional order. In this context, criminal law played a fundamental role in perpetuating colonial domination and controlling the enormous Black population after the abolition of slavery at the end of the 19th century. The legal technique allied to the judicial and medical legal practice ensured that the maintenance of Black people in a position of inferiority and marginality. The phenomenon of incarceration and the occurrence of intentional violent deaths in the country are directly linked to a drug policy. Both primarily affect the lives and access to rights of the Black people in Brazil. Although the racial data on the prison population is still problematic and certainly underreported, the latest official surveys inform that at least 70% of this population is Black, while Blacks represents only 56% of Brazilian population. In particular, there has been an increase in the female prison population in the last decades, with the number of 49,000 women incarcerated in the country, the highest number ever seen. Drug crimes account for 1/3 of all prisons in the country. Among women, this proportion is even higher. More than half of those deprived of their freedom answer for crimes related to illicit drug trafficking. In fact, drug law crimes are the most recurrent criminal types in the universe of causes of incarceration in Brazil. Drug use is still criminalized in Brazil nowadays, and the lack of objective criteria for the practical distinguishing of drug possession for personal consumption and trafficking produced a discriminatory impact of the law, as well as drastic acceleration of incarceration. Massive arrests based on drug law are concentrated on the figures of small dealers and users and affect mainly the Black and poor population, as well as women living in poverty. This is the result of institutionally racist practices of the security forces and of the criminal justice system, such as over-policing Black territories, racial profiling, personal and home searches that violate fundamental rights. A study carried out by the University of Brasilia indicated that the racial factor alongside class, gender, and other stereotypes prevails over other elements of conduct analyzed by the justice system, such as the quantity of drugs seized or the agent's role in the structure of organized crime. Another dimension of systematic rights violations promoted by the Brazilian state in the context of fighting drug trafficking is the warlike model of policing, predominantly Black territories, which led Brazil itself to recognize in a hearing at the Inter-American Commission of Human Rights in 2015, the ongoing genocide of Black youth in the country. The National Secretariat for Drug Policy understands that it's fundamental to improve access to justice in the drug policy context, in order to combat the scenario of discrimination and racism produced by the drug law enforcement. We are committed to Brazil's progresses in measures that prioritize healthcare with respect for individual autonomy, as well as the protection of freedom and privacy of Brazilians. We also consider decisive the qualification of evidential standards used by the Brazilian judiciary to convict Black people. A central theme is the value given to the police as the sole basis for convictions. The use of body cameras by the security forces can be an important element in raising the evidential standards related to drug law enforcement and preventing police arbitrariness. It's a huge coincidence that Brazilian Supreme Court will start today the trial of the case that may decriminalize drug use. This event fills us with hope for a new perspective centered in health and in respect for private life. Thank you very much for your attention, and thank you once again for this opportunity to exchange experiences and practice in favor of a more egalitarian justice for all people. Thank you very much.
Thank you very much, Livia. That's an incredible demonstration of how vulnerability makes one a victim of the criminal justice system. And we applaud your efforts in your country to try and dismantle this systemic ill treatment of the vulnerable sectors of society who are driven to drugs because they need to sustain their lives. We wish you well in your efforts.
Thank you very much.
Our next speaker who joins us online is Gunnar Thiessen. He's a human rights officer from the Office of the Special Human Rights Officer Special Procedures Branch, Office of the United Nations High Commissioner for Extreme Poverty. Gunnar, the floor is yours.
Good morning, Honorable Judge Mlambo, dear panelists, delegates, and civil society representatives. Thanks for introducing me. I'm supporting two special rapporteurs currently on a joint project on decriminalizing poverty and homelessness. This Mr. Olivier de Schutter, who apologized very much, is one of them, that he can't be with us. He's currently on a country visit, and unforeseeable circumstances in Bangladesh have not allowed him to come. Therefore, he kindly asked me to say some words here in this distinguished setting. The other rapporteur I'm supporting is a special rapporteur on the right to adequate housing, Mr. Balakrishnan Rajagopal, who also has worked a lot on this mandate on homelessness and attempts to end the criminalization of homelessness. The criminalization of poverty, I would say, is a global problem, and it's not restricted to any particular country. And we have in many countries laws, regulations that criminalize begging, of being homeless, of sleeping in a public space, of cooking, eating, or drinking, or street vending or other means of survival, whether it's sex work or other activities. Often those who undertake this, as so clearly mentioned already by our fellow human rights expert Dominic Day, do this, are already suffering discrimination or do this as a means of survival. And when you go on country visits with special rapporteurs, you think, what is, you see it sometimes very hidden, because what appears to be a very unsuspectable local ordinance of a park regulation, for example, prohibiting sleeping overnight in a park, can be the first step of a process that, after a fine is made, ends up a person being ultimately subjected to arbitrary or disproportionate detention or punishment for an activity where the person has no other alternative because she or he has no access to just merely a bed in a home. Because ultimately, when a fine is there, the person has not the money to pay the fine, then the fine is increased because of non-payment, and the national law just foresees non-payment of fines will be then corrected by a sentence in certain days of imprisonment. And it happens in many countries, including in the country where I'm currently located and working and supporting the rapporteurs in Switzerland. We had a famous case some years ago of Lakatouche against Switzerland, where ultimately the European Court of Human Rights had to decide a situation where a Roma woman who begged in the streets of Geneva was fined for begging because there was a law prohibiting in the entire canton on all the territory of Geneva begging. Subjecting that to the fine, she didn't pay the fine. In the end, she spent 5 days in detention, and the case went to the European Court on Human Rights and was finally there decided that that regulations which prohibit begging completely are not justifiable under human rights law, and also the punishment would be disproportionate. Historically, many countries have these type of vagrancy laws still in force. They were exported worldwide during colonialism as a means to regulate and control the poor or the colonized population. These laws they allowed then public authorities to detain and confine persons considered to be disorderly or vagrant, subjecting them often then to forced labor or internment in workhouses. And even with the modern human rights system, the Universal Declaration of Human Rights proclaimed 75 years ago, we had not immediately break with a lot of laws that criminalize disproportionately poor and marginalized persons, as we have already heard. And these laws appear to be very sticky. Sometimes they are even tightened and not abolished. And if we observe that these regulations are sometimes repealed at federal level, sometimes new regulations at subnational level or local level, with an array of bylaws and regulations result in similar effects. One example is, for example, the famous 1825 vagrancy law of England, which was a blueprint, which was only abolished, I think, last year after a lengthy campaign of organizations supporting people working experiencing homelessness. And this law, until very recently, allowed the detention of a person just for sleeping in a public space and submitting, I think, a fine up to £1,000. In many countries, therefore, unfortunately, the police force is tasked with clean the street campaigns occasionally, instead of fulfilling the more important and core job to protect persons without any discrimination, including those that are currently without a home from violence. Just a fact, persons in situation of homelessness, at least in street homelessness, are actually 7 times more likely to be victims of crimes, including hate crimes. And prejudices, stigmatization of the poor, including persons in situation of homelessness, blame them either for degeneration of public places or suggest that these people are prone to crime and criminality. And then in order to be tough on crime, such campaigns are then conducted, which often have then more the impact to make a prison or detention overcrowding more severe than solving the social problem that's behind. The Human Rights Council has adopted already in 2012 the guiding principles on extreme poverty and human rights. They underline that states should repeal and reform any laws that criminalize life-sustaining activities in public spaces, such as sleeping, begging, eating, or performing personal hygienic activities. Furthermore, they call upon states to review sanctions procedures that require the payment of disproportionate fines for persons living in poverty, especially those related to begging, use of public space, welfare fraud, and consider as well abolishing prison sentences for the non-payment of those fines for those unable to pay.
Gunnar, could I request that
I'm coming to conclude.
Please?
Yeah, and similar, we have a Human Rights Constitution passed shortly after that, calling upon states to take all measures necessary to eliminate legislation that criminalizes homelessness. So therefore, we, the special rapporteurs, welcome very much that currently the Commission in Vienna is considering a resolution to improve access to justice for all, and including on an expert meeting to further discuss the issue. And it's our view that's very important that both state representatives, experts from different fields, policing, criminal justice, social welfare, working with homelessness, should participate, civil society, in such considerations to to discuss further the issue, because only when working together we can solve problems which are essential, often more social problems, and should be addressed by better social policy in conjunction with the criminal justice in a way that is in conformity with human rights. Thank you.
Thank you very much, Gunnar. And without wasting more time, because we are now running very short, I would like to welcome Mr. Jesse Bernstein, the Senior Advisor from the United States Office for Access to Justice, who will discuss the challenges related to the criminalization of poverty in the context of the United States of America. Jesse, the floor is yours.
Thank you. Thank you, Judge. And I have to say, it's an honor to be on this panel, not with one judge, but two judges. Thank you to Jennifer Smith and her colleagues, Leah and Maitri, and the International Legal Foundation, for organizing this timely and important event. Our office was restored by United States Attorney General Merrick Garland as a separate office within the U.S. Department of Justice in 2021. Our office seeks to ensure that all persons can be afforded the protections of our laws on the basis of equality and with dignity. In representing the United States today, I am participating on this panel on the basis of humility and with mutual respect. We do not intend to promote one specific solution. We are here to share the experiences and challenges of the United States and discuss how we can address systematic inequities in our criminal justice systems and around the world together. First, here is some information about the United States, and I think you'll find it sounds similar to what we've already heard on the panel. The challenges facing the criminal justice system in the United States are immense. Each year, about 600,000 people in the United States enter prisons, and people are sent to jail across our country over 10 million times. At this moment, about 2 million people are incarcerated in our federal, state, and local prisons and jails. Black Americans make up 38% of the incarcerated population, despite representing only 12% of the US population. Further, routine justice system practices, like the assessment of fines or fees or citations, can lead to devastating consequences for individuals who are unable to pay. And indirect consequences can be even more devastating, such as the loss of housing, employment, access to basic necessities, and even the loss of custody of one's children. When our legal systems have the effect of criminalizing poverty, it undermines trust in our institutions and it weakens the rule of law. It also undermines our collective security and democracy. So what are we doing about these challenges? The Department of Justice is committed to combating racial discrimination and economic disparities in our justice system and policies that punish poverty. For example, in April of this year, the Department of Justice issued an official letter to justice system actors cautioning against the assessment of legal system fines and fees, which may be unlawful, racially discriminatory, and unfairly penalize individuals who may be unable to pay. The letter also encourages court and justice system stakeholders to consider the practical realities that weigh against assessing fines and fees without regard for the ability to pay. Building off this guidance, we are now conducting an in-depth review of current fines and fees practices throughout the country and preparing a report to highlight the most innovative and effective work in the area by US states, municipalities, and court officials. This report will amplify inspiring efforts already underway and seek to highlight how fines and fees may serve as a source of revenue. We hope this report and our work in this area serves as a basis for continued global engagement. The report will serve as a resource for governments, civil society organizations, and academics. We are also exploring how to include global lessons and practices in the report, and I think that's why this panel is so useful for us today. This could including working and engaging with international stakeholders to understand work and practices that are already underway in different parts of the world, such as the day fine systems embraced by many European countries. We are particularly interested to learn about examples of effective reform from other governments, and it was very interesting to hear about the work from our colleague from Brazil. This commission is about collaboration and moving forward with a shared sense of purpose and resolve. And in this regard, we hope Canada's proposed resolution on access to justice will maintain this progress. We hope this conversation is just the beginning. On behalf of the U.S. Office for Access to Justice, including my many colleagues who are back in the U.S. in Washington who are committed to this work, we look forward to ongoing collaboration and mutual support with both governments and civil society groups. Again, we hope this is just the beginning and we look forward to ongoing conversations. Thank you.
Thank you very much, Josie. Your remarks buttress the very timely need and importance of an expert group discussion that will lead the way forward on these issues. Thank you very much. I now move on to my continent, Kenya, and invite Ms. Yuli Waluya Mateka-Nyaga, the Acting Deputy Executive Director of the International Commission of Jurists in Kenya. Julie, the floor is yours.
Thank you very much, Honorable Justice Mlambo. Good morning from Nairobi, Kenya. ICJ Kenya is pleased to be part of this forum as we continue to engage and keep the conversation going regarding eliminating and combating discriminatory laws and equality within the criminal justice system. It is appreciated that a significant portion of the global population has been impacted and continues to be affected by the existence of such laws. Closer home, the situation is no different here in Africa. As a result, ICJ Kenya and its partners have been at the forefront of the battle against unjust and discriminatory laws under the banner, "Poverty is not a crime." As we know, vagrancy laws, including begging, loitering, street vending, amongst others, are still very present in most of our African countries. Many years after the end of the colonial eras, these laws remain a part of us and unfortunately to the detriment of many poor and marginalized Africans. As a result, the African Court on Human and People's Rights was approached for an advisory opinion in a quest to settle the question of the compatibility of vagrancy laws with the African Charter on Human and People's Rights and other human rights instruments applicable in Africa. The court in its decision stated that the existence of vagrancy laws is incompatible with the provisions of the African Charter, the Maputo Protocol, and the African Charter on the Rights and the Welfare of the Child, and on the basis of discrimination, limitation of fundamental rights, and arbitrary nature of their application. The court called on state parties to ensure that they amend or do away with vagrancy laws in their countries to ensure that the poor citizenry enjoy their human rights and fundamental freedoms. In addition, it is prudent that countries are guided by the African Commission principles on the decriminalization of petty offenses. It is worth noting that the Africa Court's decision clearly has had an impact on the said laws in member states. It is encouraging to note that that decision has had a positive impact in the Ugandan situation. The Ugandan Constitutional Court delivered a progressive decision in the case of Francis Tiatei versus the Attorney General, which struck down the rogue and vagabond provisions based on the right of liberty and freedom of movement. In Kenya, where I work, we have undertaken a comprehensive audit of the penal provisions that are vague and perpetuate discrimination. We are in the process of tabling an amendment bill on the floor of the National Parliament, seeking the decriminalization and reclassification of those laws. Further, we have developed national sentencing guidelines that mandate judicial officers to consider non-custodial means of sentencing while handling petty offenders, which is an offshoot of the national guidelines developed on the management of petty offenders, which ICJ Kenya supported the National Council to develop. The Africa Court's decision and the Africa Commission principles on the decriminalization of petty offenses indicates a need to remedy the wrongs of the past and have old vagrancy laws abolished and ensure the criminal justice system is pivoted on equality. There is need for continued effort in the African region and globally to ensure that unequal laws are changed or done away with. To this, ICJ Kenya posits that it will be prudent to have the International Working Group with the aim to develop a comprehensive guide that will be applied globally. ICJ Kenya believes that despite the voluminous work ahead, we shall continue this good fight and trust for more positive outcomes. Thank you very much for the opportunity to speak to this distinguished panel. Back to you, Honorable Justice Mlambo.
Thank you very much, Julie, for buttressing what Gunnar also said about what's happening in Europe in terms of adopting overarching principles and conventions that address this problem. We've run out of time, but I think I'll be remiss in not inviting Ms. Kate Fox of the Office of the High Commissioner for Human Rights, just to make very short remarks for us today. Ms. Fox.
Thank you, Judge Makumi, and to the International Legal Foundation for organising this event. OHCHR is obviously very happy to support and sponsor this event. The rights to non-discrimination and equality are rights that cut across all of the human rights treaties and all of the work of our office. And Gunnar has highlighted some of the work that our office are doing with the special rapporteurs on the area of non-discrimination and equality. So we support as an office the UN's general commitment to advocate for the decriminalisation of acts that are protected by international human rights law. The human rights treaty bodies, which monitor the implementation of the human rights treaties, have addressed a wide variety of issues criminalized in many states. Many of the issues have already been mentioned this morning. So these bodies have expressed concern about the criminalization precisely of vagrancy, of non-payment of a debt, of homelessness, of drug use, of same-sex relations, of adultery, of sex work, of moral, what are referred to as moral offences, etc. And this is just a few of the issues that they have expressed concern about. And they have looked at those issues on a variety of different articles of the treaties, from non-discrimination and equality to freedom from torture, cruel, inhuman and degrading treatment, to right to privacy, arbitrary detention, etc. And just to pull out one particularly important article, I think, from the Covenant on Civil and Political Rights, is that of Article 11, which expressly prohibits the imprisonment on the ground of inability to fulfill a contractual obligation. So this goes back to what we used to refer to as debtors' prisons, and it's a provision that's designed to protect individuals from being imprisoned because of poverty. So the treaty bodies have provided a wealth of guidance to states on resolving all of these issues, and decriminalisation is a primary one of that. I won't go any further because I know that you're stuck for time, but I should also say just finally that the office also supports the development, or was supporting the development of what we refer to as the 8th March Principles, published by the ICJ, the International Commission of Jurists, and that sets out a human rights-based approach to criminal laws addressed here today. So thank you very much for giving me the floor. And again, it was a pleasure to sponsor this very important event. Thank you.
Thank you very much, Ms. Fox. And I just want to take this opportunity to thank all my panelists for being part of this important and timely discussion. We are grateful to have had this discussion on the sidelines of the Commission on Crime Prevention and Criminal Justice, just as this body is negotiating a resolution that aims to address discrimination and injustice in criminal justice systems. I note that this resolution that is being negotiated specifically calls for an expert group to be established that would enable diverse experts to share information, evidence-based responses, lessons learned, and best practices to ensure equal access to justice without discrimination or bias of any kind. Whilst we don't yet know the outcomes of these negotiations, we remain hopeful. Our speakers today have illustrated how needed a meeting like this is important to tackle this issue. Please join me in clapping hands for all the panelists and for all the insightful remarks that they made today. And thank you very much for attending. We apologize that we ran over time a bit, but thank you very much. Let's continue this discussion.
Thank you.